This is Las Vegas Real Estate Now, where we bring you the 3 E's: educate, empower, and engage. I'm your host, Harvey Blankfeld, and we've been selling homes here in Southern Nevada since 1988. We're also talking with John Morgan today from Equity Title. He's the Vice President and Chief Title Officer. He's been doing that for 30 years. A few years ago, they created this new type of deed. It's called a deed upon death. And this is the lively topic I was trying to bring up.
Dum.
Correct.
But it's not what people think it is, though, is it, John?
It's not. The statute, the current statute that governs these things, was created in 2011. You, as a owner of a piece of property, can execute a deed on your own, have it recorded, and name as grantees in that deed whoever you want.
Right.
Typically, we're talking about your children. The deed doesn't become effective until your death.
Right.
So it kind of just hangs out there, not having any real effect. You can, at any time, change your mind and decide to sell the home, and not have to get those grantees named on that deed upon death.
Because it never was a deed, because you never died.
Correct.
Right.
So it was always conditional upon your death. And there's a lot of folks who think of that as a great way to avoid probate. To make sure that my home goes to who I want it to go to. There's a little-known statute that causes title underwriters a lot of heartburn. And this is going to be the same for any title company you go to.
Sure.
And it's NRS 111.689. And it states the creditors of the deceased person's estate have the ability for an 18-month period following the date of death to assert a claim against the home.
Wow.
And so that 18-month period, typically has the effect of ruining an escrow that's been opened up. You basically have two choices. You can wait out the 18-month period,
right,
and then list home for sale, or you can retain the services of a good probate attorney,
right,
and have a probate opened up, not for that house because the house passed outside of probate,
right,
but for all the other assets. So
the announcements are sent to all the creditors. Do it now or forever hold your peace.
And that triggers the publishing of notice to creditors. By retaining the services of a lawyer and having that notice period started, it's typically 60 days, sometimes 90, which is better than 18 months, but still oftentimes too long for a buyer to be willing to wait.
Even young couples, when you buy a home, meet with an attorney to discuss how you hold that home, in title. What title do you need? What's the best way to do it? I can't give you advice. I'm a salesman. I'm a realtor. I don't want to pretend that I know the best way, but I can tell you that a lot of times you're going to want to do a trust to protect yourself.
That's generally a good idea, just from what I've seen.
Yeah.
And that the trust allows you a lot of flexibility.
It does.
And who you want to be named as beneficiaries. You
Right.
can even put in there what you specifically want to have happen with a particular home.
You've been listening to Las Vegas Real Estate Now with host Harvey Blankfeld. Please tune in every Saturday at 11 a.m. right here on News Talk 720 KDWN.